Okay, well, it looks like a good portion of our registered attendees have logged on, so we're going to kick this off and try and stay on track for our agenda today. So good morning and welcome back to day 2 of our 33rd Annual Employment Law Seminar. I hope all of you found yesterday's sessions really worthwhile. And for those of you that are joining us for the first time today, welcome. It's great to have you as well. Yesterday was a 4-hour session, and we thank all of you for sticking with us virtually, and we really hope and intend to do this seminar, our 34th annual next year in person. My name is Jason Castor. I'm the Chief Business Development Officer for Parsons, Behle, and Latimer. And what I intend to do this morning is just give you a brief overview of the agenda and then turn the time over to our speakers. So like yesterday, today's seminar will run until noon. Each presentation will last 55 minutes, and we'll provide you with a 5-minute break in between sessions. So let's jump in quickly and talk about the agenda for today. Our first session will address hot employment law topics ranging from marijuana in the workplace to COVID issues, including telecommuting, masks, vaccinations, and more. More COVID, right? That's all we need. Our second session will focus on the 5-year anniversary of Utah's non-compete statute. This will be followed by a discussion on professional work visa options, and we will conclude the seminar with a discussion around the Fair Labor Standards Act and regular rate of pay calculations. So before I turn the time over to the presenters, I'd like to cover just a quick few housekeeping items. As we did yesterday, today's seminar is being recorded, and you will all be provided a link along with a copy of today's PowerPoint presentation to share with your colleagues and teams. This will include yesterday's PowerPoint presentations and yesterday's webinar link. Second, today's seminar is intended to be as interactive as we possibly can make it. So please feel free to submit your questions using the chat feature throughout our presentations and sessions today, and we'll do our very best to address your questions. And finally, for the purposes of CLE and HRCI credit, here's how this is going to work. For those of you who need CLE, we will submit this on your behalf and we'll send you a certificate by way of email. Similarly, for those of you needing HRCI credit, we'll email you a certificate of completion for reporting purposes. So let's jump into the agenda. As mentioned, our first presentation this morning will be a continuation of yesterday's sessions on hot employment topics that employers are currently dealing with in the workplace. I'd like to welcome in Sean Monson and Liz Mellem, who are going to be co-presenting today. Sean is a shareholder from the firm's Salt Lake City office and is the chair of the firm's employment and labor practice. He obviously focuses his practice on employment counseling and litigation. And Liz is from our Missoula office, and she is our office managing shareholder and concentrates her practice on a wide range of employment law and litigation, including sexual harassment and wrongful termination. So with that, Liz, Sean, welcome. It's great to have both of you, and I'll turn the time to you.
Thank you. It's great to be here. Good morning to everybody that's attending, and thank you for being here. We're going to dive right in, and to give you just a quick overview of what Sean and I are going to cover today, I'm going to go over marijuana legalization quickly. Then I'm going to talk about some remote work considerations, given that that really seems to be the trend now with COVID and probably following COVID. And then we're going to talk about mask policies and vaccines and claims for exemptions due to religious belief. We're going to leave as much time as we can for the mask discussion and the vaccine discussion, because I know that's where a lot of questions are for employers right now. So I'll be moving pretty quickly through the front end, but everything is in your slides, and you would always reach out and ask questions if you need to. So let's go ahead and dive in. Marijuana legalization. This is a quick map to show you guys. This came from Business Insider. It's updated as of July of 2021. Shows you where things have been voted in as recreational, medical, voted for medical, and then straight up illegal. There are about, I think it's 12 states is all that is left in the United States for where marijuana is completely illegal. Of course, it's still illegal on a federal level, but from a state standpoint, the trend really is towards, at a minimum, making medical marijuana legal, but a lot of states are also making recreational marijuana legal. So marijuana policies in the workplace, what do you do? You always want to remember that it is still illegal on a federal level. So that is really important if you are a federal contractor for any reason, or if you have some minimal federal contracts. You need to pay attention to the language in those contracts and make sure whether or not those contracts require you to have a stricter policy or a stricter scenario in your workplace than the state law does. Remember that there are different laws in different states, like we just saw on the map. So you need to think about where are your employees. From a very general level, wherever your employee is physically located and residing, that's the state's laws that are going to apply. So for those of you who now have a bunch of remote employees, because you've seen that with COVID, you can expand and hire people in different locations, you need to be aware of what the state laws are in the full employment context, not just marijuana, but be aware of that, where your employees are located. You need to be on top of providing reasonable accommodations for medical marijuana use. When someone has a prescription for it and needs to use it, you need to be working with them to figure out what is a reasonable accommodation and how you can make that work with your business. So when you are implementing a policy about marijuana in the workplace, the best practices, these are just kind of high level, is of course to say no marijuana use on the job. So basically treat it like alcohol use. For those of you who already have, and I hope all of you already have, policies about alcohol and drugs in the workplace, you can treat it like alcohol. You need to train your managers to spot signs of impairment. And that's going to come under that reasonable suspicion umbrella if you end up needing to test an employee because of an impairment. You want to review and revise your drug testing policies, and you want to stay on top of the current technology to use the best test for your workplace. I have several clients who are moving towards not even testing for marijuana on a pre-employment basis. And they're grappling with whether they test for it for random post-accident and reasonable suspicion tests, because the technology is still not great to determine how long the marijuana has been in the individual system. We, of course, get to the scenario where you may have an employee who says, well, sure, it's showing in my system, but I did that, 3 weeks ago when I was in Washington where it's legal. It's not affecting me anymore. And those are going to be kind of factual issues that you're going to have to navigate as an employer. Make sure you always have your attorney review these testing policies before you set them. They need to be different for different states to accommodate those states' laws. And there are some jurisdictions that have very specific laws about whether or not pre-employment testing for marijuana is allowed. You then also want to educate your employees about what your new or what the current marijuana use policy is, even if it's been legalized in your state as a recreational use drug. The repercussions if they have a failed test, including random tests, post-accident, and reasonable suspicion tests. And then you want to have your general or your standard, what you should always be holding, signed acknowledgements from your employee that they've read the policy, they understand it, they know the policy, and they are going to comply with it. Sean, do you have anything to add there before I move on?
Yeah, I was going to say a couple of things. One thing that I think is very interesting about
I'm having a little bit of a hard time hearing you, Sean.
Okay. Can you hear me now?
That's a lot better. Thank you.
Yeah. A couple of things about marijuana testing. One of the things that a lot of our clients, as was said, are moving away from testing for marijuana because of, the legalization in certain regards in different states, whether it's medical use or whether it's recreational use. Kind of the rule of thumb that I've used for clients when I've been counseling with them is that if you have an employee who's going to be in a particular safety situation, for example, an employee who's going to be driving a company vehicle, an employee who's going to be working on a construction site, you need to think long and hard about whether you want to get rid of your policy to test for marijuana. In other words, whether you want to keep testing for marijuana. Because that's, I think, that the biggest situation where you could have a problem is if you are not testing for medical marijuana or not testing for marijuana, and you have an employee who is in a situation that could be dangerous and causes injury either to themselves or to someone else. So that's something I think you need to think about when you're deciding whether you want to keep on testing for marijuana or not. The other comment I would make is I was talking to a friend of mine who's on the Utah legislature, and as Matt pointed out, Utah is one of the states that has legalized marijuana for medicinal use. He made the comment that, he said, I think a lot of employees are going to be surprised when they keep on getting tested for marijuana, and they may get fired. People think that just because the state legalized medical marijuana, that it's kind of a free for all. And as Liz pointed out, it's still illegal. It's still a regulated substance under federal law. So employers can still test and can still discipline for marijuana use, with the exception of, as was pointed out, if someone has a disability and they need it for a reasonable accommodation. So those are just a couple thoughts.
Sean, we've got a great question from our attendees that I want to hear your thoughts on. He's asking, is the applicable law for marijuana the state where the employee resides or where the company facility is located at which the employee works?
I would, it's the state where the employee works. That's the state that did this law, because that's where you are, we're going to be, the employee is going to be performing his or her services in the state where the company's location is. So that's the state's law that would apply, in my mind. I don't know, do you disagree with?
I think it depends on what the base question is a little. Are we talking about, if there's an accident at work and they are tested and they are found to have marijuana in their system, then it's likely going to be what's going on at the workplace and the law in that state. But if we're talking about an employee who's looking for a reasonable accommodation because they've got a medical marijuana card from the state where they live and it's valid in that state, that's a tighter question, I think, and requires a little bit of a more understanding about the facts behind it. So I agree with you generally, but I do think there are situations where we have to be really aware of where the employee resides and what the context is that the marijuana question is coming up. Okay, so shifting to everyone's favorite topic, COVID. Where we are. So the first reported COVID-19 case was January 20th of 2020 in the United States. The first reported COVID-19 death in the United States was February 6th of 2020. This was confirmed by an autopsy in April of 2020 that a woman who had passed away back in February had actually passed away from COVID, which that was not known at the time. So as of October 24th, and I actually just updated these numbers when I looked on the CDC website this morning, they're not that far off, but as of yesterday, the 27th, there were 45,571,532 total cases in the US. So about 250,000 more than what's showing on the screen there. And then in terms of total deaths as of yesterday, we are up to 737,990. So COVID, we thought it was going away. We maybe think it's going away again after it resurged, but remote work seems to not be going away. There are employees that are insisting that they want to work remotely. There are companies that are trying to figure out how to do that, how to retain their workers. And these are going to be some overview slides of things you need to consider about remote work. So remote work, of course, presents some challenges. The first is going to be that there are soft issues, right? There's the loss of the social connectedness. There's potentially loneliness for the employees that maybe feel isolated and that can negatively affect their performance and their commitment to the organization. There's also the increased risk of substance abuse and addiction by your employees. They are at home. They are out of so-called the corporate eye. They're not interacting with people as much. And if they have that sort of a mental illness, then there's a potential for it to get worse. Companies also need to understand that maybe you've got to alter your employee assistance programs and hire staff that might be trained to recognize mental health issues. Maybe this is where your normal EAP program that you have, you expand it to like the next tier up with your service provider. because there's more mental health issues and more assistance being needed by your employees and their families. You possibly need to develop some new performance management or appraisal systems for your remote working employees. There are companies that have certain types of tracking software on the computers or in the hardware that they provide to their employees, and we'll talk about that in a couple of slides. But there's also the expectation or fear from employees of companies doing that exact thing, that there is a surveillance that may apply to them when they are now not in the office or on the clock. There's also a number of legal issues that come up. And on this next slide, we'll look at kind of the overview of what to consider. And then I'm going to go through each one of these bullet points just briefly to give you some general information about each one. Honestly, every one of these bullet points could be an entire employment law seminar topic by itself, because there is a lot to talk about and a lot to think about, but we're trying to give you the end results and the high level view of what you need to be aware of. So the various legal issues to consider when you're deciding whether to allow or encourage or start offering remote work, you want to have a remote work policy. We'll talk about what goes into that, but something that clearly defines what's available to an employee. You want to be very aware of your exempt versus non-exempt employees. You want to think about the safety of your employees working from home. You want to think about whether you now will have a multi-state presence when maybe you didn't before, and how that can impact some of your employment policies and practices. You want to think about the expenses related to remote work, whether you're required to reimburse them or the employee is required to handle them. That's a different question depending on what state you're in. You also want to think about terminating a remote employee. It's not as easy as calling them into your office and saying, I'm sorry, we have to let you go, and then security walks them out. And then think about whether you want to have a remote work agreement that your employees who are taking advantage of the remote work policy agree to and sign on to. So we'll go through each one of these on the next slide. The first one, drafting and implementing a remote work policy, you want to think about, giving criteria about whether or not a specific position is appropriate for remote working. This is really to notify your employees of whether or not their position is even possible to do that, but also to give some guidelines for your management and also your HR employees so that they know how to respond to those requests. For example, if you have a factory and someone works on the factory floor and now all of a sudden they want to work remotely, it's pretty obvious that that probably isn't going to work because they need to be physically present working on the factory floor with the machines or with the materials that you're producing. Whereas someone else who maybe is in your accounting department and is at a computer terminal all day running, accounts payable and accounts receivable, maybe they are able to do that from home. So think that through about what positions you even want to make it available for. When you have a policy for remote work, it helps eliminate the subjectivity from decisions to grant or deny the remote work. For example, if somebody is well liked by management, so they get to do remote work, but someone who's in the exact same position is told, no, you can't because management doesn't like them. Having a policy that clearly defines whether or not they would actually qualify helps to eliminate that. There still will be some of that because you'll be looking at past performance potentially to know whether or not you are comfortable allowing an employee to work remotely, but it won't be so much like a favoritism thing. You also want to have your policy manage attendance and hour tracking, expenses, and productivity requirements. So how are they going to be logging their time? When are they going to be on and at the office or at their computer? Are you going to require them to come into the office maybe once a week for a weekly meeting just so that you can, do a face-to-face check-in? Those are all things you want to think about in the remote work policy. You also want to reinforce your basic company policies about drug and alcohol use to emphasize that it is inappropriate and not acceptable during work hours. And then you may need different policies for different departments or groups of employees. And this really is just talking about Employees who potentially are exempt and they do, X amount of work, then they maybe don't have to check in as much, or they don't have to track their hours as much. Whereas someone who is an exempt employee, you need to be much more strict about how they are logging their time and what types of attendance you're seeing from them. So exempt versus non-exempt remote employees, the Fair Labor Standard Act applies to all employees, regardless of whether they are working in your office or in your company building, or whether they are at home. Employees are entitled to be paid for all of the hours they work, regardless of whether or not you have a policy that requires approval before they work overtime. You still have to pay them if they do work overtime, even if they didn't get that approval. And then to telecommuters, basically, and by telecommuters, we are using that interchangeably with a remote employee. They work really on an honor system since they don't punch a clock if you don't have some sort of clock software on their computer that they're using. So you need to emphasize to non-exempt employees the importance of timely and accurate record keeping of the hours that they work. They are still entitled to the same meal and rest periods as office employees, again, on an honor system. So for example, if someone is non-exempt, they say they want their lunch from 12 to 12:30 every day, you better be watching to make sure that they're not sending emails during that time, they're not answering phone calls during that time, and they aren't working when they are supposed to be off the clock. Because if they are trying to work and catch up on things, they need to be on the clock. They need to be being paid for that time. You also want to make sure that when you're drafting a remote working agreement, that you don't have any terms in there that could potentially destroy an employee who is exempt, their exempt status. So that would be like if you try to say you have to work specific hours, or you can't make this type of a decision anymore. Those are things that you're going to need to navigate very carefully to make sure that you are holding on to their exempt status if they are someone who actually is an exempt employee. Working from home safely. This is one that a lot of employers don't think about, but from a workers' compensation point of view, you as an employer can still remain liable for a worker's injuries when the injury occurs in their home office, as long as that injury was in the course and scope of their employment. So you need to check with your workers' compensation carrier to make sure that the carrier provides the same coverage for work-related injuries at remote locations as it does for injuries that are sustained in your main headquarters or your main office. This is especially true if remote working is a new thing for your company. It also is important that, again, if you have a remote employee who's in a different jurisdiction, you are paying attention to what the workers' compensation laws are in the jurisdiction where the company is, or excuse me, where the employee is working. So if they're across state lines in the next state over, you need to be paying attention to that as well. Some certain strategies to limit liability while they're working from home is asking them to designate one room or one part of a room as their home office. You restrict the hours that the non-exempt telecommuters are allowed to work so that you know when they're going to be at their desk or when not, and therefore you have a better understanding of when accidents may occur. And then you have a signed acknowledgement from the employee that injuries that occur outside of that location or outside the specific hours will not be covered through workers' compensation. So that, for example, if they or their child maybe, trips over their chair running by at 7 o'clock at night after they're done with dinner and the employee is not working, that's not actually a workers' compensation claim. So as I've mentioned before, employees in multiple states and jurisdictions, this can present several challenges. You need to think about your tax issues because you might have to withhold and pay taxes for both states. You can also think about whether the workers' compensation coverage, unemployment insurance, and those sorts of things. With the zoning laws as well, those can come into play too. So there are some jurisdictions like New York City and I believe Seattle that have some very specific zoning laws about whether or not there is work from home allowed or home office allowed in certain locations. That may all be changing now, of course, because working from home is more prevalent, but be aware of that as well. And then think about the labor laws where they work, regardless of where your company's office is located. So for those of you who have employees in Montana or are a Montana-based employer, remember that once that employee passes their probationary period, Montana is not an at-will state. You have to have a business reason or cause to be able to terminate an employee. So if you are a business located in Nevada and you have hired a remote employee that lives and works in Montana from their home, you cannot use Nevada practices to fire that person. Once they've passed their probationary period, you would need cause to do that. This means really that you might have to learn a whole new set of laws if an employee is allowed to work in a different state or live in a different state. So just be aware of that and reach out to your counsel if you need help getting comfortable with and aware of the laws in that different jurisdiction. Home office expenses. So these are going to be, tax laws regarding the deductions, and then whether or not you pay for those expenses or the employee does. This differs by state law. So make sure you're aware of that and checking into that. We'll go to the next one. Jason, I want to make sure we're having time for the other pieces. So terminating an employee from work for working from home, it's going to be hard to get your computer and other equipment back if that employee is refusing. You don't have a legal right to enter the employee's residence to get your stuff back, and you also cannot hold their final paycheck hostage waiting for them to return the company issued equipment. So be aware that it's not so simple. Be also aware that you've got to wipe out or stop their access to all of your systems as soon as you've made the decision to terminate them and they've been notified of that. These last couple slides show a telecommuting agreement, things to make sure you have in there if you're going to do an agreement. I'll let you guys look through that. If you have any questions about that, please don't hesitate to contact me or Sean. We are happy to talk to you about it. Finally, is to just be aware of discrimination claims. So telecommuting for only a portion of your employees can lead to a discrimination claim, even if that's not what you intended. It's called a disparate impact claim. So for example, if you say, oh, well, the only department in our whole business that could do this is our accounting department, and it just so happens that your accounting department only has women working in it, and you then deny a male the opportunity to work from home because he's not part of the accounting department, that should be a red flag for you, because there's a potential for a discrimination claim. It doesn't necessarily mean that you did actually discriminate. It just means that he may have the basis for a claim. Next slide, please.
Liz, before you transition, we've got a couple of questions that have come in.
Okay.
If you can see the chat feature, if not, I'll read them.
Go ahead, Jason.
So first question, Liz, does an at-will status change if the ER is in employer, yeah, there we go, is in Montana, and the EE, the employee is in Idaho?
It's a good question. I think it's going to fall back to what the company's policies are. So if you are a Montana-based employer, your policies most likely state and comply with Montana law, or should. And therefore, you have to apply that same policy to this Idaho employee. It's something that you might be able to cure with an employment agreement, but it would be tricky. And I would make sure that you're following the stricter law just to be safe. But it's certainly something that's going to depend on the facts and depend on what the actual policies are of that employer.
Great, thanks, Liz. And one more question. If an existing employee starts working remotely, can the employer restrict them from moving to another state where the employer may not want to be subject to those states' laws? And if so, is that something that could be handled in the remote work policy?
It's an employee who wants to move to California, right?
Yeah. Yeah, I mean, if the company is allowing remote work as a possible or optional policy, but not like a standard, everybody gets to do it if they want to, it's still an employer policy, and the employer should have written in their policy that it's their discretion whether or not to allow the remote work, and their discretion whether or not to allow it in certain instances. So as long as you are not restricting that employee in some sort of way that may be seen as discriminatory, it is totally up to and allowable for the employer to say, sorry, that's not within the bounds of our policy, and in our discretion, that's not good for the company.
Great. Thank you very much, Liz.
Yeah. So this slide is just common mistakes to avoid, goes to kind of the discrimination part, and then all the things you want to think about when going into your policy. And we'll skip forward. So now masking. I'm going to quickly go through a few of these slides about masking. And I can tell you right now that I have in here that this is Ada County. That was from Idaho. So with these masking policies, it is changing constantly, right? The CDC is saying, yes, you do want to have masks. No, you don't have to have masks. Oh, it's a good idea to wear masks. The best practice for your company is going to be based on a couple of different factors. Next slide, please. So generally, it's up to you whether you require your employees to wear a mask while working. The EEOC, the Equal Employment Opportunity Commission, says you can require masks, but if you choose to require them, the best practice is to provide those masks to the employees. So they, of course, can wear their own if they have their own type of mask that is acceptable to the employer, but also maybe have, you know, a thing right by your front door where there are disposable masks available for them to grab on their way in case they forgot one. Now remember that that's the EEOC, that's federal guidance, that's not state law. So for those of you who are Montana based, you need to remember that you cannot treat your employees differently based on whether they're vaccinated. So with respect to masks, it is a all or none thing if you are a Montana employer. You cannot say, like employers can in other jurisdictions, oh, if you're not vaccinated, it's okay, I'm not going to make you wear a mask, but you do have to wear a mask if you're not vaccinated. Or excuse me, if you are vaccinated, you don't need to wear a mask. If you're not vaccinated, you do need to wear a mask. Employers in other jurisdictions that are not Montana, you are currently okay or within your bounds to make that kind of delineation. Montana, that is right now a giant no-no because of HB 702, the anti-discrimination law that went into effect this year, making a person's vaccination status a protected class. Be aware that the guidance and the laws on this are changing constantly, especially now that the pandemic has drug on and we've been, you know, in the midst of it more. It's happening more in more locations where different jurisdictions are changing what is an option for employers. So please be on top of that. And then when you're drafting a face mask policy, because you do want a policy, you do want it documented, you do want something you can rely on, and something, frankly, that me and Sean can rely on. If we need to defend you from a discrimination claim, we can say, look, this was their policy. This is what they had written out. Everybody knew it. When you're drafting that kind of policy, take these things into account. I'll let you read through them, but essentially you want to make sure that you're clear and that you're taking into account what the local rules and the national rules are. Those things seem like they can be conflicting, right? Being clear, but also taking into account all these different rules that seem like they might be going back and forth or conflicting with each other. So it can be difficult to navigate. We are happy to help you with that if you need a face mask policy for your company. and masking exemptions or exceptions. So in exemptions, you may have someone who can actually reasonably refuse to wear a mask. That would be, for example, if a mask interferes with the performance of an employee's job, like it fogs up their glasses and they're unable to see, or if the mask creates a workplace hazard. So, for example, like cutting, instead of welding, if someone's cutting with an open flame, they don't want a mask on their face because that's an OSHA hazard. It's flammable, and it could potentially cause a problem. So you would do something else for those employees in that scenario. It's also possible the mask could aggravate a medical condition. If an employee seeks an exemption due to a medical or religious reason, you always want to engage in your interactive dialogue as the ADA requires. And I'm going to turn it over to Sean to talk to you about religious exemptions and whether or not accommodations are required for vaccines.
Thanks, Liz. So I think in both of our practices, probably the last month, we've, at least me, and I know Liz as well, is about 60% or 70% of my work has been how to navigate vaccinations and whether they're required, whether they're not required, and then with the announced but as yet unseen federal OSHA rule about the mandate for employers with more than 100 employees. Vaccination has taken up a lot of bandwidth in our practice. So just kind of a little bit of an overview. As I'm sure you all are aware, the EEOC has said that an employer can mandate vaccines. And again, the federal government OSHA will be promulgating a rule. We expect at any time that employers with more than 100 employees are required to essentially have employees be tested or vaccinated. And so that's kind of from the federal level. But as Liz said, states have had their own rules as well. For example, Washington and Oregon have required some employees before the federal rule was announced in the healthcare setting to be vaccinated by October 18th. And in Montana, as Liz noted, there is vaccination status as a protected class. So an employer can't require an employee to get vaccinated under Montana law. Now, obviously, once that federal rule was announced under OSHA, there are going to be lawsuits, and the lawsuits are going to be based on or talk about the issue of which law is essentially supreme, the federal OSHA rule or the state statute, and that's going to be an interesting case to watch in Montana. There are exemptions to the vaccination requirements. The first exemption is a disability exemption. This is essentially similar to someone who has an ADA disability. I do know that that there is some information that, for example, the neurological condition of Guillain-Barré syndrome is a physical condition that could be exacerbated or could be made worse by the vaccine, the COVID-19 vaccine. So the first kind of exemption to the vaccination requirement, again, is disability. And a disability under the ADA is a physical or mental impairment that substantially limits a major life activity. If you have an employee that claims that they have a disability and they can't take the vaccine because of that disability, you as the employer can require them to provide medical certification that they have the disability, and two, that the COVID-19 vaccine will harm or exacerbate that individual because of their disability. So those are kind of the two things. So with the disability exemption to the vaccine mandate, it's pretty clear cut. If you want to require vaccinations in the workplace, if you want to have a policy that requires vaccinations, an employee claims that they can't take the vaccine because of disability, you can require them to show the medical certification that they have the disability and that the COVID-19 will exacerbate the disability. Next slide. And then if they demonstrate that disability, then you have to go through an accommodation process. And that's similar to any other kind of ADA accommodation process that you are all familiar with. You have to go through the interactive process, try to find if there's some alternative to the vaccine requirement that you can have this employee do that would enable them to continue to perform their job but wouldn't pose a safety risk to the employee or to those that are working with the employee or to customers. And we'll talk about what some of those accommodations might look like. The other exemption is the religious exemption under Title VII, and that is much more tricky. Normally when there's a whole bunch of case law regarding the religious accommodation requirements under Title VII. Title VII, of course, is the federal statute that makes it unlawful to discriminate against an employee because of the race, national origin, gender, or religion. And one of the components of Title VII is a religious accommodation, and that is an employer is required to accommodate unless it constitutes an undue hardship in employees' religious beliefs. And normally, when you have a religious accommodation situation, it's a situation where the employee, wants to wear certain clothing, wants to take a break to engage in a prayer practice or something during the day or something like that. And oftentimes it's the employer who is resisting the accommodation because of the interference with the workplace and interference with the employee's work schedule. With the COVID-19 accommodation request, the vaccine accommodation request, it's oftentimes the employers that want to require the employee to get the vaccine, and so it's kind of most of the time employers are resisting these kind of religious accommodation requests, and in the COVID-19 vaccination context, the employer again is resisting it, but it's a little bit of a different context because the employer essentially says we want you to get this vaccine. So it's a little bit of a different dynamic than you normally see in the other religious accommodation cases. So kind of where the battle is with these religious accommodation requests is what constitutes a religious belief. It's very, very squishy. And one of the things that you see as a lawyer that really is disconcerting is when cases talk about that the rule or the case is decided on a case-by-case basis. And that means there's really no good guidance that you can apply uniformly across all your cases. It's decided on a quote-unquote case-by-case basis. It really doesn't provide you with a lot of certainty about how you can approach, and how can you make decisions when people say, I have a religious belief. It's really not well defined. And I'll just give you some examples of what I mean by how it's not well defined. Courts have said that religion includes all aspects of religious observance and practice as well as belief, not just practices that are mandated or prohibited by a tenet of the individual's faith. It includes not only traditional religions such as Christianity, Judaism, Islam, but also religious beliefs that are new, uncommon, not part of a formal church or sect, only subscribed to by a small number of people, or that seem illogical or unreasonable to others. Next slide. A belief is religious for Title VII purposes if it is religious in a person's own scheme of things, i.e. it is sincere and meaningful belief that occupies a place in the life of its possessor parallel to that filled by God. The Supreme Court has made it clear that it is not a court's role to determine the reasonableness of an individual's religious beliefs, and that religious beliefs need not be acceptable, logical, consistent, or comprehensible to others. Next slide. So it can be the employee. An employee can have a religious belief even if it is not part of the even if it's kind of the individual's own take on a established religion and the established religion's tenets. So in other words, the employee might say, I'm a Catholic, but I also have a religious belief that might not necessarily be subscribed to and well established as a tenet of the Catholic religion. So employers generally should assume that an employee's stated religious belief is reasonable. Is sincerely held. But if the employer has reasonable belief or reasons to believe that the employee, the religious belief of the employee is not sincerely held, then the employer can ask for documentation confirming the religious belief, and or can ask for the opportunity to speak with the employee's religious leader. Next slide. Okay. So yeah, so again, if the employer has reason to believe that the employee stated religious belief is not sincerely held, the employer can ask for documentation, or can ask for, regarding the religious belief, or can ask for the opportunity or the information from the employee's religious leader. Next slide. Okay, so just, when I do this in person, I ask people if anyone knows what this logo is. This is the logo for the Church of the Flying Spaghetti Monster. Which, next slide. And the Church of the Flying Spaghetti Monster is commonly known as Pastafarianism. And here's some of their belief: that the flying spaghetti monster created the universe after being heavily intoxicated. The monster's intoxication was the cause of the Earth's imperfections. All evidence for evolution was planted by the spaghetti monster as a way to test its believers' faith. Next slide. The conception of heaven in the Church of the Spaghetti Monster is that it includes a beer volcano and a stripper, or sometimes a prostitute factory. And the Pastafarian hell is similar, except that the beer is stale and the strippers have sexually transmitted disease. Obviously, this is a joke, but it kind of, and this was started by a person essentially to test the limits of what could constitute a religious belief. And there's cases where this person went to court, and there are cases that talk about this quote unquote religion. But it kind of shows you the limits to which, and the struggles that you have as an employer, you know, kind of delineating between what is a sincerely held religious belief and what is not. The slides we just went through kind of talk about and illustrate concepts the courts have set out regarding what constitutes a religious belief, but you know, it's not clear. It's uncertain. There's not a clear, bright line. But there have been some general concepts the courts have given that can help. Religion generally includes things about life, the purpose of life and death, the ultimate ideas of life, the big questions. Next slide. And this is language from what a court, one of the court cases. First, religion addresses fundamental and ultimate questions having to do with deep and imponderable matters. A religion is comprehensive in nature. It consists of a belief system as opposed to an isolated teaching. A religion often can be recognized by the presence of certain formal and external signs. So if someone's religious belief is just that I don't want to take the COVID-19 vaccine, that's probably not going to fly. If someone's religious belief is, I don't ever take any kind of vaccines and I'll take any kind of medical intervention, that is much more akin to what would be a legitimate, sincerely held religious belief that courts would recognize. It can't just be an isolated teaching. It has to be more of a comprehensive set of beliefs that impact the bigger pictures, the bigger questions of life, such as the purpose of life, the meaning of life and death. A couple of other points is that a person does not surrender or does not forfeit their religious belief just because they're not scrupulous in their adherence to it. So if, in other words, you have a Catholic who says, I have these Catholic tenets of my religion that I adhere to, they prohibit me from doing, this, or they prohibit me from getting a vaccination. Just because that person doesn't go to mass, just because that person doesn't go to confession, does not mean that they can't have those sincerely held religious beliefs. A person's inactivity within the religion is not necessarily limit or discredit their sincerely held religious belief. Next slide. Okay, so here's some things though that might undermine their credibility. So when you have an employee who's saying, I have the sincerely held religious belief, and you as an employer are not sure about that, and you think there's reason to believe that the belief is not sincerely held, and you question that, and you're asking for documentation from the person, from the employee about their religious belief, you're asking information from their religious leader. Here's some factors, though, as you're making that determination of, is this sincerely held or is this not sincerely held, that you can consider. Whether the person has behaved in a manner that is markedly inconsistent. Now, again, the previous slide said just because they aren't active doesn't mean that they forfeit their religious beliefs, but it is a factor. If they behave in a way that is inconsistent, and they repeatedly behave in a way that is inconsistent with the stated religious belief, that is a factor that would indicate that it is not sincerely held. Whether the accommodation sought as a particularly desirable benefit that is likely to be sought for secular reason. Whether the timing of the request makes it suspect. And what I mean by this is suppose that the employee, and I had this in the case, the employee first said, I can't take the vaccine because of a disability. And the employer said, well, show us your disability. So we need medical certification of disability. The employee didn't provide it. Then the employee came back a week later and said, okay, I can't take the vaccine now because of a sincerely held religious belief. That timing and the fact that the employee first said, I can't take the vaccine because of a disability, and then later said, I can't take the vaccine because of a sincerely held religious belief, that timing and sequence of events is a factor that you can consider in saying, well, maybe this really isn't sincerely held. And other reasons that you might have to believe that the belief is not sincerely held. Next slide. Okay, so assuming you get through the process of the employee says, I have this religious accommodation request, you go through the process and determine that it is a sincerely held religious belief, that's not the end of the inquiry. The inquiry then goes to, okay, what accommodation can you give the employee that would allow them to not take the vaccine and still perform their job? So these are some of the factors that you look at. If the employee doesn't get the vaccine, would it pose a direct threat to the employee in the workplace? Would it pose a direct threat to coworkers? Would it pose a direct threat to customers or clients? Would it cause an undue burden to the employer? Those are all factors you're going to be looking at to determine whether you can reasonably accommodate this employee's request to not get the COVID-19 vaccine. Next slide. So there's other factors when you're looking at that. Some of the factors to look at in determining whether the employee poses a risk or not poses a risk is whether the employee works alone, or with others, or outside, inside or outside, available ventilation, the frequency with which the employee typically has with other employees, the number of partially or fully vaccinated individuals the employee is going to be working with, whether the employee or other employees are wearing masks or undergoing routine screening testing, and the space available for social distancing. Okay.
Sean, I want to jump in real quick and ask a question that we've got in the chat, because it goes to knowing how many vaccinated people are already in the workplace when you're making this kind of assessment.
Right.
Can you verify an employee's vaccination status? And if yes, how do you do that? And I'm going to let you answer, and then I'm going to answer for Montana.
Okay, right. Yes, you can verify. And the EOC said you can verify the employee's vaccination status. How we would do that, you would either get a photocopy of their vaccination card, a note from a physician that they received it, or any other kind of evidence that would indicate that they have been vaccinated. That the important thing, though, with that information is you must keep it separate, treat it as any other kind of medical information. Under the ADA, an employer has an obligation to treat employees' medical information as confidential. That means that it's in a separate file, it's not in their personnel file, and there's limited access to it.
Okay, so in Montana, if you're a Montana employer, you can ask if someone is vaccinated, but you cannot require them to answer the question, and you cannot treat them differently based on their answer. So just generally, I have been advising clients who are in Montana to not even bother with the question, because even if you are trying to determine how many of your employees are vaccinated to know kind of whether, within your little microcosm, you might have reached herd immunity, and you're just wanting it for basic knowledge, the fact that you're asking the question and keeping track, and then perhaps do something like change that employee who refused to answer the question, change their schedule or reduce their work hours for a completely unrelated reason, that could open you up to a discrimination claim, given how hot of a topic it is in Montana right now. So I have just been recommending to not even ask, but if employees volunteer it, you absolutely can take that volunteered information, and just like Sean said, you keep it confidential in a separate file away from their personnel file, and where really only one, maybe two people in the HR level or higher have access to it.
Running out of time, I just wanted to real quickly comment on what you do, what kind of accommodations you might be looking at, and really the accommodations for people who refuse to get vaccinated because of a disability or a sincerely held religious belief, or similar to the accommodation issues we discussed, early on in the pandemic of trying to protect people that are in the vulnerable populations. You talk about having those employees wear masks. You talk about having those employees not work close to other coworkers. You talk about maybe having those employees telecommute. And certainly going forward, not just for COVID-19, but if for any kind of disability accommodation request, teleworking or telecommuting is going to be it's going to be hard to argue for most employers that allow their employees to telecommute during the peak of the pandemic to now say, well, having an employee telecommute is going to cause me an undue burden if it's a position that the employee can telecommute from and effectively perform their job. And again, that is not necessarily just limited to COVID-19. That's to all kind of ADA accommodation requests. So those are kind of some of the things you need to think about when you are thinking about those accommodation. When you're thinking about how do I accommodate an employee who has a sincerely held religious belief or has a disability. Again, having them wear masks, having them not interact or socially distance or work workplaces where they're not interacting as much with customers or other employees, having them telework. Those are kind of things you need to do. And what you're looking at is can this accommodation, if the employee doesn't get vaccinated, still keep the employee safe, still keep the other coworkers safe, still keep the customers safe, and not constitute an undue burden? Meaning, in my view, essentially, can they still perform their job reasonably without a significant increase in expense to the employer by allowing this particular accommodation? So that's kind of, I think we're probably up at our time. Thanks everyone for attending. Some of the additional information is in the slide deck that we weren't able to get to. And if you have any other questions at any time, please email Liz or I. Our contact information is on our firm's website, as well as in the materials at the beginning after the seminar is over. Thanks, everyone.
Great job, Sean and Liz. Thank you very much. Great presentation. We'll kick off our next session here in just a couple of minutes. We'll give you a break to stretch your legs, and we'll see you just in a couple minutes. Thank you.
Great, thanks.